Today I'm going to talk about your protections under the Bankruptcy Code. When you file a Chapter 7 or a Chapter 13 bankruptcy, an automatic stay, a protection, a shield goes up against your creditors. The automatic stay is the most powerful injunction in the federal code. It stops all collections from all creditors with limited exceptions. If a creditor is aware of your bankruptcy and attempts to collect a debt, such as by calling you to still collect money or repossessing your car, and they don't stop immediately, they can be held in contempt of court. It is a very serious offense against the creditor. If a creditor does that, you are entitled to be awarded your actual damages from having to, such as coming to our office, possibly emotional distress. The attorney fees, you will not have to pay us any attorney fees. The creditor will pay us the attorney fees if they are in violation of the automatic stay, and possibly punitive damages for violation of this important law. If a creditor knowingly violates the bankruptcy stay, many times punitive damages are awarded. Some of the other examples of the automatic stay is that if a creditor conducts a foreclosure sale just an hour after your bankruptcy is filed and does not know about your bankruptcy, that foreclosure sale is voided. If a creditor repossesses your motor vehicle and does not give it back, the creditor is in violation of the automatic stay. Even if a creditor repossesses your motor vehicle before you file bankruptcy, generally if the 10-day period that you have to cure your default or pay up the creditor has not gone by, we can file a Chapter 13. The creditor must give your car back because he's holding it in trust for you until you pay. After the 10-day period, if you don't file bankruptcy, a creditor has a right to sell the car at an auction sale. But please remember that you have a significant number of protections once you file bankruptcy. Now, once you retain our office, the automatic stay does not go into effect. But please let me remind you that once our office is retained, we will give you a card so you know what to tell your creditors. You become a representative party, which has some legal significance. Being a representative party means that once you advise a third-party debt collector, such as a debt buyer collection agency, and you have a consumer debt, they can no longer collect against you, or they are in violation of a federal statute called the Fair Debt Collection Practices Act. So please remember, even though you have retained us and the automatic stay is not in effect, you have some significant rights. We will also write letters, if you request, to let your creditors know of the filing date. We will advise your creditors not to communicate with you. If they do communicate with you in violation of our letter, and you happen to record it and request that you be allowed to record that call and they continue to harass you, that could be evidence in a harassment lawsuit, or, again, if it's a third-party debt collector, a Fair Debt Collection Practices Act lawsuit. If you're ever going to use a tape recorder, please always tell the person on the other line that you are taping the conversation. Even though you don't have to do that in the state of Tennessee, it is my legal recommendation that you always, always, always announce that you are tape recording a phone call. But in any event, once you file bankruptcy, you have a number of serious protections, and if there's violations, there are serious consequences against your creditors. Thank you.